Okay, welcome everybody to today's webinar on the literal ins and outs of SMSF trusteeship. So it's one of those subject matters that I always think is kind of at the not at the bottom of our learning sort of curve, because we often set self-managed super funds up and then we sort of don't think too much about the trusteeship until often it's quite late in the piece, and we actually need to rush into to make some changes on behalf of a fund. So I find it to be one of those really good topics to sort of refresh ourselves on a sort of semi-regular basis. And we talk about pensions and contributions and the like all the time, but I think it's always good to sort of touch base with the trusteeship side of things, to I guess to make sure that we can go over our own client bases to look at what scenarios we might find ourselves in or have within our own fund client base, and see if there's any sort of circumstance that we need to consider. So, what are we going to look at today? I'm going to look at the structure of a self-managed super fund. I am going to look at what trustee obligations are. So I'll touch on the trustee covenants and a couple of other key issues, sort of just to introduce it, work through that definitional structure side of a self-managed fund, the stuff that we should all know about membership and trusteeship, but also where it can potentially catch us out in that sort of area. Then touch on I guess, the combination of alternate trustees and event-based trusteeship. So what sort of scenarios create a situation where we have to look at potentially changing the trustees, or look at whether we need to change the trustees. So there's a little bit for us to work through. I'll make some references to scenarios that I've dealt with throughout my time in the industry, but also have a look at a couple of cases, just sort of from a reference point of view, to highlight, where there are some key considerations that we need to work through. So, membership's not forever. Why did I start with that as a sort of an introduction? Well, what I thought I'd do is touch on very upfront the key issues that I see from a trusteeship point of view that change the dynamic of self-managed superannuation funds, and change the structural need of self-managed superannuation funds. And a self-managed fund is an indefinitely continuing fund. So unlike trusts that have a trust life, a self-managed super fund can go forever. Membership can't go forever. Okay, so we appreciate that members will often be outlived by the fund, and if we apply the appropriate trustee structure, being say a corporate trustee, well then the company itself can also last as long as the trust is in operation. So we're going to have these situations where, if we want to retain the same entity, we're able to do so, but we will need to look at the parties coming in, going out of that fund throughout time. And so, what I look at from a trustee decision making point of view, and I've tried to sort of break this down into, I guess, the imagery that will make us resonate with events in life to determine where trusteeship will be a consideration. So you've got your membership decisions. So scenarios where someone might go from a single member fund, they might become a couple. That couple might turn into a family, and then we're going to look at the needs then of adding additional family members to the self-managed superannuation fund. Appreciating that I've got a dog in the picture, and we know that dogs can't be members of self-managed funds, although I suspect many people would be more than happy to do that. And then we've got to deal with relationship breakdowns, right? And relationship breakdowns are certainly a big issue when it comes to SMSF trustees and SMSF trustee structures. So we've got that natural flowing membership decision to make based on our own personal set of circumstances and our family position. Then we've got troubled situations. Okay, so we've got situations where something happens to the members of the fund, right, or something historically has happened with the members of the fund that is going to determine their eligibility to be a trustee of a self-managed super fund, and indeed a member of a self-managed super fund, because there are going to be circumstances, and I'll touch on disqualification through today's session, where you cannot have a self-managed superannuation fund, and so you have to look at what the alternatives are in that regard. And ultimately, there's only really one set of circumstances where you can't be the member of a fund, and that is when you are a disqualified person. So we'll look at the options there. And then we have our alternate trustee opportunities or scenarios or events that occur that will potentially lead us down the path of having to appoint somebody else in certain circumstances, or making relatively quick decisions once an event has occurred, and not necessarily changing the trusteeship immediately, subject to the decision making process that we go through in the fund. So things like traveling overseas, and I'll spend a bit of time on that Australian super fund definition today as well, and how that applies. Disability or incapacity is clearly a key issue, and then the death of a member. So we've got these multitude of scenarios that are going to apply throughout the lifetime of an individual who is looking to be a member of a self-managed super fund. And what we need to work out is what the impact is going to be from a trusteeship point of view in those sets of circumstances. So we need to understand, of course, when we're working through this, because a key piece, when I've spoken a lot to trustees over my time in industry, and had the conversations, or had given presentations to them about their obligations as trustees. And most people that jump into a self-managed super fund, and I say most because there are those that do it, not necessarily unwillingly, but they do it just to go along for the ride, and aren't necessarily um, big in the decision making, and others, and let other parties do it for them. And so you question whether they should have a self-managed fund or not. But most people that at least jump into the concept of having a self-managed super fund understand that with that comes the responsibility as being a trustee of the fund, and with that comes all your legal requirements that are linked to trusteeship. And so the obvious ones that apply are our SIS covenants that are incorporated into every fund, every deed that we have from an SMSF point of view. We have those trustee covenants that we have to follow, right? And so, we know these. We should know these. We should know these if we're dealing in self-managed super fund. To act honestly in all matters concerning the fund. This is a great. I love this as covenant number one, because whenever I get a technical question and somebody says, they want to do something, and then they say, well, you know, what if we tried to do this, or what if we tried to do that? So, well, you've just got to look at covenant number one, act honestly in all matters concerning the funds. So if you're trying to undertake a transaction, and there is some level of dishonesty, then you're failing your covenants right from the outset. So, we've got to have clarity of process, and clarity of understanding with regards to sole purpose test, all of those other requirements, and it falls well and truly into the trustee covenant piece of operation from a fund point of view. Due to exercise in relation to all matters affecting the fund, degree of care, skill, and diligence, as an ordinary person would exercise in dealing with the property of another whom the person felt morally bound to provide. The duty to exercise powers in the best financial interest of the beneficiaries. And this best financial interest is obviously something from an advice point of view that people have to understand, and take consideration into, or take into consideration when establishing self-managed super funds. But then once we're trustees, we also have to look at, is this decision in the best financial interest of the beneficiaries? And so again, we're looking at things such as liquidity. We're looking at high risk investments and the timing of high risk investments. Not to say that someone can't undertake high risk, but looking at the timeframes of membership. Is someone close to retirement? Is someone drawing down income streams? How are those decisions going to impact it? So, without going through all of the trustee covenants one by one, it's important to recognise that we've got all of these various obligations as trustee of the fund that we have to take into consideration, all the way through to the drawing up of obviously the fund's investment strategy, and then not only drawing up the investment strategy, but following the investment strategy and trying to achieve the financial outcomes that we're ultimately referencing within the investment strategy of the fund. And so the reason why I put this all up here and up front is because when we're looking at particularly replacing somebody with another party, where that person isn't the member and doesn't have a vested immediate interest. Now, appreciate they might have a beneficial interest in the sense that they may be the member's beneficiary, and so they might have a future interest in the event that the member passes away. People have to understand that when they're taking on the role of alternate trustee, or the trustee in place of the member, that they are equally required to follow the trustee covenants. They are equally required to satisfy all of the investment considerations and restrictions of the fund, and they're equally subject to the penalty regime than the original trustees and members were. And so when we're making that decision to replace someone, the person who is replacing the member must go in there with eyes wide open as to what their responsibilities are. But we take that all the way back to fund establishment, and when we've got a new person coming into the fund, be it a child, be it a spouse, whatever it might be, they've got to understand that this is not just where their super guarantee contributions are going. This is where their contributions, their personal contributions are going, and then they're involved in the decision making process with how those monies are going to be invested, with the long-term goal of providing retirement benefits. So, having that clarity around what your obligations are is really important. And some of you would have experienced this before, when a fund has been set up, and the tax office send out a communication. They might ring the trustees themselves, and they will start asking them some questions. And this is a process that the ATO have been doing for well over 20 years, in regards to trustee education piece, where they want to make sure that trustees understand what their obligations are. And ever since 2007, where the requirement to sign a trustee declaration came into legislation, there's been far more of that communication from the ATO to make sure that trustees are not just being a trustee because someone's told them to, that they're understanding what their obligations are. And so not only do they need to sign a trustee declaration that identifies that they understand their responsibilities regarding contributions, income stream payments, investment restrictions, and other trustee duties, but they also have consented to act in that role. So again, if we're looking at appointing somebody's legal personal representative, that there is actually an appointment process that the fund has to go through, which includes that individual consenting to act in the place of the trustee of the fund, and then signing their declaration. Now, interestingly, very recently, the ATO came out and updated their website and their trustee declaration form, because there was some speculation, some questions being raised around the whole idea of how long you need to keep a trustee declaration form. Now, while the legislation hasn't changed in this scope since it was introduced back for 2007, ultimately it all hinged on this 10-year concept. Was, did you only have to hold a trustee declaration? Does the fund only have to hold the declaration for 10 years? And so what the ATO clarified is you have to hold it for the longer of your time as a fund trustee, or 10 years, so whichever is longer. So therefore, if you are a member of the fund and you leave after 5 years, the trustee declaration must be retained for 5. But if you're a member of the fund for 20 years, then you've got to hold that trustee declaration for that full 20-year period. So the ATO came out and clarified that position recently, and they updated their form. So that's just one to put in the memory banks there from a trustee declaration piece. So again, understanding what our obligations are, not just under the trustee covenants, but also from a trustee declaration point of view, that we have that understanding of all of the various investment considerations and that we need to take on board when acting as trustee of the fund. So when we're looking at our trusteeship considerations, what are the things that we have to have some form of clarity on? What do we need to have understanding on? Well, we always have that conversation around corporate versus individual, and statistically, we all have a great appreciation that basically 3/4 of all self-managed super funds are set up with corporate trustee versus individual. And so, and there's some really good reasons for that, and I'll touch on a couple of those considerations in a moment. But that whole corporate versus individual is something that people need to take on board. Then some of the key definitions within the definition of a self-managed superannuation fund. So one of them is the definition of relative, and that's linked to employer, because one of the things, as I'll go through in a moment, is that the fund, you can't be in a fund with your employer unless that employer is a relative. So then you need to understand who is a relative. And it's an interesting area because the definition of relative is used on multiple occasions in the SIS Act, and it has different definitions, it has different meanings based on what you're using the definition for. So important to have that understanding there. You need to know who a member is because there are requirements from a timing point of view. If you add a member to a fund, there are requirements with regards to the immediacy with a need to change the trustee structure. So if you've got a new member being added to the fund, you need to act immediately to reflect that in the trusteeship. However, if that new member is the non-member spouse, so if we've gone through a separation and the non-member spouse is receiving some of the member's interest, then yes, they're a new member, but for the definition of a self-managed fund, we don't have to add them as a trustee until 6 months after the serving of the court orders or the consent, whatever it is, and the operative time. Now, in most instances, of course, most people would hope that the non-member spouse would no longer be a member after that 6-month period, i.e. the process has occurred, the benefits have been split, and the non-member spouse's benefits have been transferred to another fund. But sometimes these things take a bit of time and they will retain their membership for a longer period. And if that period exceeds 6 months, then they have to become a trustee. I also appreciate that most non-member spouses for family law purposes are already members of self-managed superannuation funds, and often the split is just happening internally, but there are circumstances when that non-member is not actually a member of the fund. And of course, we then need to understand employer with how it's linked to the definition of relatives for not being able to be a fund member with your employer. We also need to understand the restrictions. So the trustee remuneration, I'm not going to focus on trustee remuneration as part of today's webinar, but other than to highlight that we need to appreciate that we cannot be remunerated in our role as trustee, but we can be remunerated for anything we do in our individual capacity. And of course, we know that that then has arm's length ramifications. So we need to make sure that those transactions are done on an arm's length basis. Disqualification, so there are restrictions linked around whether or not we're a disqualified person or not. And then we need to understand what our definition of our legal personal representative is. So our alternate trustee in death, in disablement, and in certain other circumstances. And then we also need to appreciate the roles that parents can play if we're bringing children into a superannuation fund. So a number of factors that we have to take into consideration for our definition of a self-managed fund. So clearly, as we know that we can have up to 6 members in a fund, and from a trustee structural point of view, what is clear for all multi-member funds, so when there's more than one member in the superannuation fund, is all members must be individual trustees or all members must be director of the corporate trustee. So we know that that's how the rules apply. Members can't be employees and directors can't be employees of another member unless they are relatives, and we'll come back to that scenario in a moment. And then no members can be remunerated in their role as trustee of the fund. So you've got your standard that applies for both individuals and corporate trustees. Why do we go one or the other? There's all sorts of reasons. I know cost is one that's often spoken about, and it's interesting. I was reading some articles in the preparation for this, where if we take the lifetime of a fund and we incorporate the costs associated with the removal of individual trustees over time, and that might just be a time cost. Where does that weigh up with regards to, say, the annual admin cost or the annual asset cost for having a corporate trustee, given that the annual fee for a corporate trustee is so minimal for a special purpose company, and we're looking at what's that, about $70. I should know, I paid mine recently, but that fee is pretty negligible in the scheme of things to have that consistency, particularly with the ability when we're moving members in and out to not have to worry about changing the asset registers for the superannuation fund. So we've got our multi-member funds, and then for our single member funds, this is where we do have different or differences between individual and corporate, and that is if we've got individual trustees, we must have that second trustee. So it's a legislative requirement that we have to have a second trustee, and we can't be the employer. They can't be our employer in that instance there. The remuneration stuff's all the same. With a corporate trustee, we can have single member, sole director companies. So you've got, from a corporate trustee point of view, you've got your two options. You can have single member, sole director, or you can have single member with a second director, as long as that second director is not your employer. So you do have that opportunity there, which is why, again, and we'll talk about death as we progress through the webinar. But when we talk about the death of a member, if you've got a corporate trustee with two directors and one passes away, then the fund is going to continue to satisfy the definition, because you've got that sole director, sole member scenario following the death of the first member. So it's all relatively straightforward from an administrative ease point of view to consider. But one of the key things is this definition of relatives. And this is a slide that I've used for a long time now with regards to identifying who relatives are, and this is a very green slide compared to normally. There's a few a few red areas there with regards to the definition of relative for related parties. Right. So when we're talking about investment restrictions inside self-managed superannuation funds, the definition of relative is different to the definition of relative for Section 17A. And 17A is all about who can be in the fund together. Now, of course, once you're all in the same fund, you're related by virtue of the definition of a Part 8 associate. But it's quite a broad list as to the extension of who relatives are. And so you've got your your easy to understand ones, your parents, your children, grandparents, grandchildren, your siblings, right? And then you've got, by definition, and this is where it starts to get quite sort of significant, is your aunt, including the great aunt, uncles, including great uncles, nieces, nephews, cousins, both first and second cousins. Then you've got your spouse, your former spouse, and then the spouse or former spouse of any of these relatives listed. So that's quite a broad list when we're incorporating who we work for to work out whether we can be in the same self-managed superannuation fund. It's a lot of deep and meaningful family relationships for scenarios which ultimately don't apply in most circumstances, given most people are in funds with either themselves, their spouse, or their occasionally their parents and occasionally their siblings. So it's quite a broad definition that we need to consider with regards to whether or not we're in a fund with our employer, by looking at that broader family. And just out of interest, I dug this up because it's always intrigued me. I'm pushing well into my early to mid 50s now, and I always contemplated, when we start to talk about cousins and you hear first cousins, second cousins, all sorts of things. I never really, went much beyond first cousins in regards to definition point of view. But I found this table to be quite fascinating, so I thought I'd chuck it in here for people to have as a reference point, because in the definition of related party, we have this definition of lineal descendant, and lineal descendant is that top line, right? So the person, their parents, their grandparents, their great grandparents, their great great grandparents, and then their children, their grandchildren, and their great great grandchildren, right? That's a lineal descendant. Everybody else on that list is not lineal. It's that word there that starts with a C. I'm not even going to try and pronounce that one. But as you see here, things like cousins and great aunts and that, they often link to how far up that lineal descendancy chart you go. So once you start going into great grandparents, that's where you start to hit great aunts and great uncles. But it's where you also start to hit second cousins as opposed to first cousins. So I just found that to be quite a fascinating slide for inclusion. No real other reason to provide it there. And of course, the other thing that we have to be mindful of with our self-managed funds is the concept of our director ID, and we know that we need to apply for our director ID before becoming a trustee. So this is relevant when we've got somebody who is the legal personal representative. I mean, it's easy, again, when we're talking about setting up a new fund, we can go through a checklist and say, right, well, have you got a director ID? Yes, okay, let's set up the company, we can go through that process. But if somebody's a legal person or representative because of the will or because of the enduring power of attorney, have they got a director's ID? Have we gone through that process? Have they been made aware that they'll need to get a director's ID? So where timing can be important, it's critical that everybody understands all of the requirements that they need in order for them to be a trustee or a director of the fund. And so then our final group, which is those people that can't be trustees of a self-managed superannuation fund, and this is our disqualified persons. And a disqualified person is stated under Section 120 of the SIS Act, right? So someone that's been convicted of an offence in respect of dishonest conduct. Now, the ATO highlight dishonest conduct to include fraud, theft, illegal activity, or dealings, right? So ultimately, what you're talking about here with dishonest conduct is financial crimes, right? So anything where there is a financial element linked to it is largely where this concept is just dishonest conduct is going to come into consideration. And so once you have been convicted of a dishonest conduct based crime, then you can't be trustee of a self-managed superannuation fund. Or if you already are trustee and you commit one of these crimes, then you have to be removed as the trustee of a fund. Also, if you're subject to a civil penalty order under the SIS Act, if you're insolvent under administration, an undisclosed bankrupt, or have been disqualified by the regulator under Section 126A of the SIS Act. I'll come and talk about that in a moment there. And again, the same thing flows through for our corporate corporate trustees. If you're the responsible officer and you've been disqualified, if the company's gone into receivership, or as being forced to wind up through its activities. So there are certain circumstances which will determine you to be a disqualified person. But one of them is this concept of the 126A disqualification, where the commissioner can disqualify you for not being a fit and proper person. So this is where they won't look at your actual criminal activity as such, because that's already a given with regards to whether you can participate as trustee or not. They'll actually look at your activity in regards to trusteeship, um, and ongoing behaviours. And there's actually been quite a number of cases in the last 2 to 3 years where individuals have been disqualified by being deemed to be not a fit and proper person by the commissioner. And the two that I've highlighted there was Coronica and Merchant. Now, Merchant was the Billabong case, and Coronica, he was a tax agent and accountant with like 50 years experience. And Coronica did a lot of loans to themselves, a lot of sort of questionable transactions inside the superannuation fund, acquisition of assets that they couldn't otherwise undertake, some dodgy market valuations. So there was just a history of events that led to their disqualification. Merchant was the fund where they transferred Billabong shares from the family trust to the superannuation fund, and that created a massive tax loss in the family trust, and they ultimately were proven to have failed the sole purpose test from a super point of view. So even though we can acquire listed securities, um, the tax office said, well, the purpose wasn't to provide for your retirement. The purpose was to provide for the tax benefit for family trust. And this has gone through multiple cases in recent times. But the commissioner landed on a disqualification, and then there was an appeal to that because they basically said, well, hang on, from a fit and proper person point of view, we haven't actually this is not a common thing. We've undertaken one transaction in the history of our trusteeship, and that was to transfer these shares in. We transferred those shares in based on advice on the fact that it was possible under Section 66 to acquire certain shares. So we actually haven't deliberately done anything wrong that would suggest that we would jeopardize the financial position of the superannuation fund. Ultimately, we just got that tax benefit in the family trust. So they actually overturned that, and they were able to be the trustee of their fund. There were other conditions placed on them, but the commissioner has the capacity to to effectively remove somebody. You also, if you are have been found guilty of dishonest conduct, you can apply for a waiver of your disqualification. Now, the interesting thing here is that you've got to do it within 14 days of the offence. Now, most people will have done these offences many years ago, and it could be as a child. They could have stolen something as a child and been found guilty. They could have done something overseas, been charged with something overseas, and their record might not be appearing in Australia. So you then have to rely on applying for an extension to that 14 days before you can then apply for the waiver to disqualification. So it's quite a lengthy process that if somebody wants to go through to ultimately become a trustee of the fund. But if you've been convicted of serious dishonest conduct, so the penalty was either 2 years imprisonment, and it's the penalty given, not the penalty served. So 2 years imprisonment or 120 penalty units, which is 120 times whatever 313 or whatever the number is at the moment as a penalty. So if the penalty was significant enough, you can never be trustee of the superannuation fund. So it's one of those situations where it's why setting up a fund, you're basically making a declaration that you're not a disqualified person, and on an annual basis, you're continuing to make that declaration that we're not disqualified, so we can continue to act as the trustee of the fund. So let's now look at this whole concept of alternate trustees. So we understand all members must be trustees and all trustees must be members. But what are the circumstances? What are the situations that arise that result in us not being able to be trustee or not wanting to be trustee? So there's going to be different circumstances. So scenarios where it's by our actions and other circumstances where it's going to be by our decisions to appoint someone else. So you've got your simple one, which is your single member fund. So it really isn't an alternate trustee scenario. It's just that you potentially are going to have that second person in there as that second trustee or that second director. So ensuring that that person understands their responsibility to come on board as trustee of the fund. If we've got a child who's under the age of 18, right, we can appoint their legal personal representative. We appreciate, and the legislation appreciates, that most people under the age of 18 don't have a legal personal representative. Some will. So some will have court-appointed legal personal representatives, but the majority of people will have parents and or guardians, or not, and parents or guardians. I guess some will have and or, but parents or guardians can act in the person's place. Now, I'm going to talk a little bit more in a moment about, multiple replacement trustees and those other issues. So for now, we're just identifying who can be the replacement trustee. If you've got somebody who is overseas, well, then you can appoint somebody who holds an enduring power of attorney on behalf of the member. If someone's under a legal disability, so if their legal disability isn't age, so if the legal disability is incapacity, then they're going to have a legal personal representative. And again, that could be a court-appointed legal personal representative, or it could be somebody who holds an enduring power of attorney. We then have the death of the member, where we're going to have the legal personal representative, again, being the executor of the will or the holders of letters of administration for that individual. And then we've got our disqualified person. Now, this is a breakaway from the other funds, because in every other situation, so all 5 situations above, you can have a self-managed superannuation fund. If you're disqualified, you can't have a self-managed superannuation fund, or more to the point, you can't be the member within somebody else's self-managed superannuation fund. You can still have a fund with less than 6 members, but it must be a small APRA fund, right? So you must appoint a small APRA approved trustee to be the trustee of the superannuation fund. So it's not acceptable to have the legal personal representative of a disqualified person replace them as trustee of the fund. So, small APRA funds are still out there. The numbers have diminished significantly over the last sort of 20 years, but they do still exist and they are still an option with regards to the fund. And I say that more so from not an establishment point of view, because again, you're probably going to need to be pretty serious about what you're doing if you're going to set up a small APRA fund to start with. And that might be because of the investments that you're looking to go down rather than the structure itself. So you might want to invest in property, but don't want to be trustee. So you want to go on appoint an approved trustee. But if you're going to do that, If you're going to appoint an approved trustee, a small APRA trustee, you've got to have an appreciation for what investments they're willing to hold, because they might not be willing to hold property on behalf of a fund. So understanding all of those sorts of elements there. Where this occurs more often than not is where you've got existing self-managed super fund members, and they might become disqualified due to, say, bankruptcy. Now that's going to disqualify them for, let's say, a period of 3 years. So instead of winding their fund up and moving their money over to a retail or an industry fund, they might look to appoint the approved trustee to be able to keep that fund structure in place. So there are alternate trustee scenarios. This image here is one that I've used before to really highlight some of the key things that we need to consider when it comes to these alternate trustees. So, if I probably should have done it the other way around, started with the parent guardian up the top and had death down the bottom there. But what we're looking at is, what other things do we have to consider when we've got this alternate person as the trustee of the fund? So from a parent's point of view, well, the children are going to turn 18. So what are the administrative considerations when that child turns 18 that we have to think about there? Why they're in the fund in the first place is obviously one of the key questions. And, it's a legitimate question to ask, and there might be legitimate reasons to bring the children into the fund. But then what's the ongoing impact on things like the investment strategies and the like with reference to the fund? As we move through the enduring power of attorneys, what are our conditions from an appointment point of view? What additional conditions are placed on that individual under the enduring power of attorney? As I said, I'm going to talk about this more specifically as we move beyond this slide. But, are they just being appointed as trustee of the fund, or do they also have some powers effectively as the member from an EPOA point of view, particularly under legal disability? So if someone's incapacitated, and then from a death point of view, do we understand from the deed point of view if there needs to be an appointment? Do we understand how long the appointment is going to be for? And then what are our contingencies in place for when the death benefits have been paid and the legal personal representative has been removed? So these are all things that we have to consider as part of the requirement to appoint somebody as an alternate trustee of a self-managed superannuation fund. So let's look at this from a concept point of view, and then I'll touch specifically and probably a little bit more in depth into the Australian Super Fund piece in a moment. But what 17A3 gives us is it gives us the capacity to appoint somebody else as trustee in the place of the member. Right now, when we're talking about death, as I just sort of alluded to, you have a situation where we can appoint somebody in the place of the member, right? And can is one of the key words. It's not a must, so it's not a requirement under the SIS Act. It is more a capacity to do this if we choose, or if our deed mandates us to. So the trust deed is, from an alternate trustee point of view, the trust deed is going to be a critical document because it's going to dictate what rules are in place with regards to any appointment and removal. So from a death benefit point of view, we've got the legislative ability to appoint a legal personal representative. However, that appointment is restricted until the death benefit commences to be paid. So anyone that's heard me talk about death benefits will know that if we've got a reversionary and pension in place, and that's all we've got in place, then you can't appoint the LPR. Right? The LPR can't be appointed because the death benefit commences to be paid immediately. It's only if you've got non-reversionary pensions or accumulation interests that you would contemplate the ability to appoint the legal personal representative, and then you would refer back to the deed as to whether or not you can do it. Same with capacity. So if somebody has an enduring power of attorney, and what is critical here is we're talking about enduring powers of attorney. So you can just make a power of attorney, but it doesn't endure through the loss of capacity. Once you've made that enduring power of attorney, then the law effectively dictates that that individual who has lost capacity doesn't have the ability to make decisions anymore. Right? So the law provides the ability for us to appoint our legal personal representative who holds an enduring power of attorney in the place of the member. So that's for disability, but we also then have the capacity under that 17 uh, A3 to just appoint our enduring power of attorney at any given point in time. So if somebody holds an enduring power of attorney on our behalf, they can replace us as trustee of the fund. But what's important is that they're not acting on our behalf, they are acting instead of us. So it requires a removal of the member as trustee of the fund. So from a disability point of view, the deed would normally dictate how that's done, but the removal of the member. But if the member is of sound mind, they will be able to resign as trustee of the fund, and then that person holding the enduring power of attorney, who is our legal personal representative, will do their full appointment. They'll sign their consent, they will sign the declaration, and they will either join the company as a director of the company, or they'll join the fund as an individual trustee. And then they're fully in charge, well, not fully depending on the membership, but they are then in effect a trustee of the fund. So it's not somebody acting on somebody else's behalf. And this is where there's always been confusion when it comes to enduring powers of attorney, because people say, well, I'm acting under an enduring power of attorney. No, you're not, right? From a trusteeship point of view, you're not acting under an enduring power of attorney. In fact, you can't act as trustee under an enduring power of attorney. The enduring power of attorney is simply the tool that gives you the ability to be appointed as the legal personal representative of the member you are replacing, right? So the EPOA doesn't have any power over the superannuation fund itself. However, the flip side of that is an EPOA has as much power as you give it when you prepare it. So there are circumstances, there are cases in the past where the member, under the enduring power of attorney, has given their attorney the power to amend binding death benefit nominations, to make decisions about benefit payments, to change pension instructions, to do other things inside the fund. That's a separate issue to trusteeship, right? And if that occurs, right, and that individual is acting under the enduring power of attorney, then that's not in their trustee capacity, that's in their capacity as effectively a replacement member, right? So it's really important to distinguish between those two key points. And what that means is the appointment is an appointment in your own right. Now, the classic case here is, and I've already spoken a little bit about death benefits, right? And I said that from a death benefit point of view, the legal personal representative can be appointed from the date of death up until the death benefit commences to be paid. So that's set in the legislation. Under the enduring power of attorney, there is no such setting from a timeframe point of view. And this Dawson and Dawson case, or Dawson v. Dawson from 2019, again, it's your classic blended family situation where the father had appointed his son as his enduring power of attorney. He was in a second marriage, and he had actually made the son of his new partner the executor of his estate, right? So there's two different males as two different legal personal representatives. He had early onset dementia, and so he resigned as trustee, and he appointed his son under the enduring power of attorney to be trustee of the self-managed superannuation fund with the new wife. They were going through a divorce. So it wasn't too new. They were going through a divorce, and she was remaining in the fund until all the benefits were paid out. There was some genuine property delays and things like that. So there was legitimate reasons why the benefits weren't being paid out. But in the meantime, he died. Now, when he passed away, the wife slash ex-wife and her son tried to do a deed amendment to remove the other son, and they tried to invoke that, well, he was only the enduring power of attorney, and so on death, that enduring power of attorney was no longer valid, and therefore he was no longer trustee, and now the LPR from the will is the new trustee of the fund. But the courts held that he was appointed in his own right to replace the member under 17A3, under that enduring power of attorney, and there is no removal clause within there unless the individual elects to be removed. And now there was issues around fund membership and other things, but the key is once you're appointed under an EPOA, you're appointed until you actually go through the process of removing either yourself or the or in agreement with the member. So it can actually be a significant decision that's actually being made in those sets of circumstances. And similarly with multiple attorneys, right? So the classic one is if we've got children, right, then vast majority of children are going to have two parents, right? So they're going to have two parents, likely in the self-managed superannuation fund, child under the age of 18. How many parents can they appoint to act on their behalf as trustee of the fund? One or two, right? You can do either or. You can have one parent or you can have both parents. Can that parent already be the member of a self-managed super fund? Yes, right? So you might have self-managed super fund, corporate trustee, single member parent, brings in multiple children under the age of 18, acts as director in place of all of those children. So the fund might have four members. It looks like it's only got one trustee or one director, but because that parent is acting in multiple capacities, it meets the definition of a self-managed superannuation fund. And that's what SMSF ruling 2010/2 confirms. Right. What I will say is that from a practical point of view, you will run into trouble with the tax office with regards to these structures, right? And that's a that's system-based trouble, right? It's not compliance-based trouble. It's more the system doesn't like any anomaly when it comes to the recording of trusteeship and enduring powers of attorney and those sorts of unaligned membership issues. So just be prepared that when you're going to appoint potentially one or more people into a effective single capacity, it's going to create problems, but they're not legislative problems. They're not compliance issues for the fund because the fund is acting in accordance with 17A and that 3, that alternate trustee bit. So if you've got multiple attorneys, if you've got multiple enduring powers of attorney, if you've got multiple executors of your estate, you can choose to appoint, or they can choose to appoint all of them themselves, one, a selection of, it's got to be a decision. And generally, because trusteeship has got to be an agreed based decision, it's best if these parties get together, because what we know from all the cases is when they don't get together, that's when the problems are created. So understanding that is key to it, but there is no restriction on the numbers that are appointed, and there is no restriction on existing members taking on that role as well, which is often the case, obviously, from a spouse point of view when there's a death benefit or even a disability scenario. Again, I've seen it plenty of times where we've had clients who have lost capacity, and you speak to the spouse and say you can be the trustee in their place, and they'll often say, "Well, look, my spouse has an enduring power of attorney," and they name myself and my child or our child as the powers of attorney or as the attorney. So, I'd like for effectively spreading of power, I'd like to appoint the child as the trustee in the place of the member. So people will make those decisions if they're given the choices of what's available to them. The next part of it is really, what about those clients that are traveling overseas? Because this has always been an area of misunderstanding from what opportunities actually exist from an SMSF point of view. And it's also been captured in the super reform environment, in the sense that for the last 5 years, governments have been proposing changes to this whole definition of an Australian super fund, which will exclusively, I say exclusively, impact self-managed funds, because the definition of an Australian super fund is generally only tarnished by two parts of the definition, and that is central management and control, which is the trustee decision-making part, and the active member test, which is the contributory part. And so government reform has talked up extending and expanding central management and control, and government reform has talked about removing the active member test, so to allow people that are overseas, allow them the capacity to contribute to a self-managed fund. But as I've highlighted here, I'm not focusing on the establishment rules and I'm not focusing on the active member requirement. I'm looking exclusively at the central management and control piece because the rules are very flexible with regards to maintaining central management and control if you've got members both in Australia and overseas, right? They're a little bit less flexible if you've got members overseas, but if we've got members overseas, then it really comes down to lots of questions like why are they overseas? How long are they overseas, right? And are they coming back to Australia? So what central management and control is, it is looking at the high level strategic decisions of the fund, right? So where are the trustees when they are making the high level strategic decisions of the fund, right? If they're overseas, is that overseasness temporary or permanent? So would they ordinarily be in Australia? And again, just like the SMSF ruling 2010/2, the tax office dealt with this, I think, very well back in 2008. So with TR 2008/9, they addressed a lot of this issue with regards to central management and control and the ability for trustees to be overseas and still make decisions for self-managed super funds. So what we're looking at is who's making the high level strategic decisions. So we need to know what they are, right? So high level strategic decisions are obviously the formulation and the reviewing of the fund's investment strategy, right? That is high level strategic decision. Buying and selling shares, not high level. That's just transactional, right? The benefit payment decisions, right? Should we start a pension for the clients, at transition to retirement age, all these sorts of things? That is high level strategic. Paying the benefit, once a decision's been made, paying the benefit is a day-to-day activity. It's not high level, it's not strategic. So day-to-day activities, buying, selling shares, paying benefits, receiving contributions, those sorts of things are not high-level strategic decisions. It's more the issues that are linked to a lot of the regulatory requirements around the fund's investment strategy. So that's the first thing. The second thing is how many trustees are overseas versus how many of them are in Australia. Because if you have 50/50, for example, so you've got one trustee in Australia and one trustee overseas, then the ruling is quite specific to say that you've got central management and control in two countries. And as long as it's 50/50, and as long as the decision-making powers are equal, then that central management and control will be in Australia. So if you've got someone permanently in Australia who is an equal decision maker with the person overseas, right, who might be over there for an extended period of time, then you've got central management and control in Australia. So that also makes the process quite easy. Then we look at, okay, well, if we don't meet that 50/50 requirement or greater than 50% in Australia, right? So it's got to be at least 50, but it can be more in Australia. And it's got to be an active trustee in Australia. Then why are they overseas? What is their purpose and what is their time? Because if they are ordinarily in Australia, so they're on holidays, right? But everything else about them is Australian based. They've still got all their assets, they've still got their home, still at work, whatever it might be in Australia. They're just overseas on a temporary basis. Then the trusteeship is ordinarily in Australia, and it doesn't matter that decisions are made whilst they're overseas. There is a safety net there which says temporary absence can be up to 2 years, right? So if you go away up to 2 years, you're coming back at that 2-year point, right? Then your absence is temporary. If you go away and it's permanent, then the 2 years is not relevant. Like from day one, you have to make a decision around the trusteeship of the fund. Then the other piece of that is like the purpose and time, if you're not in that 2-year window, is if you're over there for the fulfillment of a specific purpose. You might be over there for study, you might be over there for a job. And on completion of that study, on completion of that job, on completion of that medical treatment, you are returning to Australia, then you're over there for the fulfillment of a specific purpose, and you can still meet that temporary absence requirement and make decisions while you're overseas. Do trustees need to return to Australia to make the decisions? no, not based on the 50-50 requirement and not based on the temporary absent requirement. However, if they do return to Australia and they meet with their advisor, they meet with the other trustee, and they make their decisions, they review the fund, they review all the decisions whilst they're in Australia, then 100% they're going to satisfy that requirement, because the active member test, the contribution test, is a tax residency test, right? The central management and control is a literal physical test. Where are you where you're making that decision, right? And they've got all these caveats that allow you to make the decision overseas under the temporary notion. But if you are physically in Australia when you're making the decisions, then all the rest is totally irrelevant. Doesn't matter what your tax status is or anything. The central management and control at that point in time is in Australia. So, it's a complex area, but it's actually quite simple when you break it down into those key areas there. And if they need to appoint somebody else, do they appoint somebody who holds the enduring power of attorney? Do they bring a new member into the fund, right? And this can often be the scenario. If you've got 2 members in the fund, we know we can have up to 6. If you've got other family members, can you bring them in so that whilst you're away and making decisions, you've still got more than 50% in Australia? So there's different ways to contemplate meeting the requirement. And yes, appointing your enduring power of attorney is one way. The ruling does talk about, as does the SMSF ruling, delegating trustee powers. That's a slippery slope to me, because it's an area that goes down the path of what does your deed say with regards to the ability to delegate trustee powers. So I've always been heavily favourable to the proper appointment and removal, or acknowledging that you do satisfy the central management and control requirements. But they're the sorts of things that I would consider there. All right. So the last few slides that I just want to touch on with you is really just, and I'm not going to go through these in any sort of high level detail, is really, we've got the situation where there might be a change of trustee, right? So we know that we have to do our reporting. We have to report to ASIC 28 days, tax office within 28 days. We then have to make sure that if we've got asset registries, that we're updating those other asset registries, and other financial institutions, which is why often when there's a death benefit, often the legal personal representative won't be appointed, because the time frame is short. So even though the legislation provides for it, often the fund won't do it, because all the additional work that's involved just for a very small time frame. So we need to make sure that we meet our asset requirements and our ATO requirements there, but also that we're doing everything in accordance with what the deed said. And I made the reference earlier today to the non-member spouse, from a separation point of view. So, understanding the definition of a member from both the SIS Act, but also within the deed. Why is there going to be a change needed? How soon do we have to do it? In all circumstances, it's 6 months. So if we're adding somebody, so if we've removed the trustee, we've got up to 6 months to add the new one to satisfy the definition, except for the addition of a new member. But as I said before, if the addition is because of relationship breakdown, then you do have the 6 months. So the key thing, basically, the next few slides really just highlight some key points for you, about what decision-making powers are held both within the deed, right? So it's important to recognise what the deed says, in regards to replacement rules, and conformity with the deed and the requirements there. So understanding what's required there. What is required from a corporate trustee point of view. So not just what the deed says, but what the Constitution says. And we often see changes to the deed, but not the Constitution. So making sure those 2 documents are aligned, and meeting and doing the appropriate forms with regards to the corporate trustee. And again, really just sort of looking through, and this is a bit repetitive now, those key issues to make sure that if somebody's retiring, if somebody's resigning or whatever, that we're meeting the various conditions, whether it be incapacity, or whether it be the death of the member. So taking into consideration all those elements. Now, what I have highlighted through there is what we do at Smarter SMSF is we build a document platform, and we've got a fairly significant number of documents that deal with change of trustees. So always happy for people to reach out if they've got any questions in that regard. I have had a question here. In a single member fund, can a corporate trustee have a second director be an overseas resident who returns to Australia annually to review super? Yeah, you can. So can you have a single member fund? Can you have that second corporate trustee, and can that second corporate trustee be an overseas resident who returns to Australia to review? So I said yes straight away. I was very quick in saying yes. They've got to be an Australian at some point in time, right? You've got to have a tax file number to be a trustee, right? So you can't just be someone that's always lived overseas and doesn't have a tax file number in Australia, because then you can't register. You can't be registered as a trustee of a self-managed super fund. So the answer is yes, you can do it. As I said, they don't even have to return. If they're 50-50 in the decision-making process, that overseas resident doesn't even have to return. But if they do return, then that provides absolute clarity for them. So something to be mindful of. So again, it's always about making the best decisions for your fund, and as part of the establishment of the ongoing basis. There is a lot of clients that are in this situation. So we really always want to address it and review client situations to make sure we've got things covered when there is a life event, death, disability, but also travel as a significant one. Understanding the process, understanding how we go about the change of trustees is important. As I said, I've just referenced our deed, our constitution in those previous slides, but it's important that you review your client's deeds, your client's situation, to make sure you're doing the processes appropriately. And there are services out there, and again, we also offer a legal review service. So we partner with a law firm who helps us with the preparation of our documents, and they will actually review documents. So if you've ever got a situation that you don't know the answer to, then certainly there's groups like ourselves who are out there who can help in that scenario. Okay, that's it. Thanks for attending. A couple of events. I've still earmarked next month for revisiting Div 296. We're getting closer to Parliament resuming, so they're resuming in, I think, 7 days, something like that. So we'll know a little bit more there, but I'm still planning on doing a Div 296 revision in August. Just as an additional thing there, Smarter, we do quarterly, or we do 3 masterclasses a year. We've got an annual compliance masterclass, so you can always visit our website to have a look at that event there. And then I'll have a bit of a think about what the September webinar is, as I'm preparing for Div 296. So we'll see if the government come out with any nuggets in the next couple of weeks. Otherwise, I'll look back at what we haven't done to focus on what we can do moving forward. So as always, you'll get a copy of the presentation. SuperGuardian will send that through to you with your CPD. Thank you all for attending, and I look forward to catching up with you all in August. Thanks very much. See you later.